Today we'll answer the question once and for all, is an embryo property or human life, and why you can and should counsel clients on the difference. Listen to the end. The answer may surprise you. Welcome to LifeCast, Attorney Edition, a LifeCounsel podcast. I'm Jesse Bifulco, an estate planning and elder law attorney with over 20 years in the practice and business of law. On this show, we'll explore the challenges and opportunities of running a law practice that not only serves clients well, but sustains the lawyer behind it. Each episode is designed to help you find that balance between intention and profitability, between professional growth and personal life. I want to help you find what Tony Robbins calls pull motivation, the reason behind what you do that makes the difficult work feel effortless. Because here at LifeCounsel, we believe your practice should work for your life, not the other way around. Here's a question for you as an attorney. Have you ever stopped yourself from giving a client your opinion about the ethics of a legal decision they're contemplating? Today, we'll talk about why you might have stopped yourself and the attorney rule of conduct that says you shouldn't. We're also going to give you a framework for estate planning for frozen embryos. We're talking about something both scientific and spiritual, personal and public, and still evolving: embryos, inheritance, and the question of life. We'll look at how different states define when legally life begins, what that means for estate planning, and how new technology is changing a very old human question. Who are our descendants? And along the way, we'll rediscover why lawyers of conscience are part of the moral nervous system of the law itself. So what are we talking about? In Alabama, a patient wandered into a cryogenic storage area, picked up a canister of embryos, dropped it, and destroyed them. The Alabama Supreme Court later declared those embryos extrauterine children. IVF clinics paused services overnight, unsure whether a routine procedure might now expose them to wrongful death claims. In Los Angeles, two couples gave birth to each other's babies. The embryos were swapped. The families bonded with children who weren't biologically theirs, then swapped infants after DNA testing. In Indiana, a fertility doctor secretly used his own sperm for decades, fathering dozens of children without consent. The families only learned the truth through consumer DNA testing. In Cleveland and San Francisco, thousands of embryos were lost when cryogenic freezers failed during the same weekend, turning parents' hopes into grief. These incidents aren't rare outliers anymore. They're warnings. Technology moves faster than ethics, and the law scrambles behind both, trying to catch up. Every one of those cases began with hope and ended with paperwork, litigation, and loss. So where does that leave the counselor at law who's standing beside the hopeful couple? When an incident like this happens, what are the rights and remedies? As my old contracts professor used to say, it depends. The law has always defined life, but that definition changes over time. Before Christianity, no civilization on earth made it illegal to own people and treat them as property. The unborn were also treated as property. Infants could be killed or exposed, and slaves were property their owners were free to kill. The rationale was utilitarian. Household economics, the father's line of descent, the city's stability, power defined the rights of the powerless. We hear that now and call it barbaric. We call our civilization progressive because along the spectrum of human behavior, most agree that treating human beings as property was a less civilized behavior. And since we now acknowledge that practice as ethically wrong, and the law backs it up, we have progressed. Or at least we hope civilization has progressed. But have we? That question isn't rhetorical, it's diagnostic. I'm asking the lawyers listening, is that true? Have we progressed? We all remember our law school moot court assignments. In law school, my moot court assignment was to represent the plaintiff against a doctor in a wrongful life case. That was a new thing back in the 90s when I was a freshman. What is wrongful life? To this day, I don't know, because it's a contradiction in terms to anyone who puts a value on all human life. Literally, the gist of the plaintiff's claim was that if a child is born when the parent didn't want it, the doctor could be liable to pay the cost of raising the child. Recognizing that cause of action incentivizes the medical profession to err on the side of ending rather than promoting new life. What if, when I was assigned to the plaintiff's side of that case, I simply said to the professor, "No, I think that it is immoral and unethical, and I'm not going to do it." Would I have been congratulated for being more progressive or given an F? Wrongful life sounds like the Roman practice of exposure. Maybe wrongful life was the beginning of normalizing the justification for the ancient Roman practice where a father could let a newborn child die if the child might interfere with his line of succession. We're progressing now in a different way by expanding the franchise, because now the franchise, the right to terminate the infant, is extended to the mother and not just reserved for the patriarch. In other words, the economic justification for infanticide is being given a hearing in our own court system, allowing this regressive practice to creep back into the world. You'll also notice that a doctor who's supposed to encourage life is liable to be punished for succeeding. Today, that's a viable claim in 4 states. The point is, we're trained in law school to argue any position in the name of professionalism. We're told we can suspend our conscience, so we can see all sides. But somewhere in that suspension, we stop seeing clearly at all. The embryo debate, like those wrongful life hypotheticals, isn't just about language or precedent. It's about what happens when conscience gets put on administrative leave. Many people, many lawyers, most major religions consider the embryo a form of human life, not property. Yet most states treat embryos as property. Aside from the ethical dilemma, practically speaking, state law inconsistency matters in estate planning. The words in a will or trust might be managing more than assets. They might be managing genetic material. No matter what you or your client personally believe about the embryo, you both must plan for how your state sees it. Biologically, an embryo is the early stage of human development after fertilization. In science, it's a stage. In ethics, it's a question. In law, it's a gray zone. We've also learned to keep those categories in separate boxes. My science brain says it's fine. My gut says maybe not. But it's just biology, right? So we start saying stage or product or material instead of child, descendant, and life. Lawyers are especially vulnerable to this compartmentalizing, exactly because of our training. My moot court story is not unique. We're trained to put aside our moral judgment and advocate a position. We call it professionalism, but isn't it something more like sophistry? Without an ethical limit on the parameters of a legal claim, it becomes a game, an intellectual challenge. In my 25 years of practice, I've seen some pretty wacky claims and defenses, but I've never once seen a judge sanction an attorney or even throw out a claim because it lacked, quote, good faith argument for an extension, modification, or reversal of existing law. And that's what Rule 3.1 regulates that we do. We're not supposed to bring a claim unless it fits in there, right? If it's outside of those parameters, we're not supposed to bring it. And yet, I've seen arguments outside those parameters, and the judge really doesn't care. Every law student remembers the moment you're assigned the defense of a murderer or write a memo supporting a wrongful life claim. Deep down, you think, no. To defend what's wrong is also wrong. Say that out loud and you'll fail the modern version of pluralism and your moot court assignment. The idea that every position, no matter how outrageous, is just another valid point of view. Pluralism originally meant one individual holding multiple offices. It's about reconciling multiple responsibilities in our reckoning of judgment. What's being sold as pluralism today is really relativism, the claim that no judgment can ever be made about anything. And once that seed of relativism takes root in the profession, the profession that writes the laws, it doesn't stay in the classroom. It grows into statutes and opinions that reflect it. Just like over time, somehow, doctors became liable for carrying out their mission successfully, bringing a new life into the world. Pluralism changed from being something positive and constructive to a way to accuse anyone of having moral parameters, of being intolerant, maybe even superstitious. What that means today is that the dominant policy concern must reflect a broad consensus. Some would say too broad. The fig leaf for intellectual elites or the faux progressives is democracy. They shout down opposing viewpoints by declaring the decision was decided democratically. But that's simply not true. Did we have a referendum on the viability of wrongful life claims? I don't remember a referendum in my state to decide if embryos were property or human life. And once you accept that relativism in the classroom, it follows you into the courtroom, heck, into every aspect of your life. At a cocktail party, I once had an educated, successful man tell me a story. He told me a story about how he sold his expensive car on Facebook. The buyer paid with a check, and the check bounced. Objectively, that's a cause of action for conversion and a criminal offense. But he decided not to press charges because the man was a recent immigrant of a minority status. In recollection, I'm not even sure that the guy got his car back. And he was so proud of being stolen from to boot. Relativism shows up in statutes, in estate plans, and in our vocabulary. When a culture stops believing in moral absolutes, its laws stop reflecting moral clarity. We start calling contradictions policy compromises. We become 50 moral universes under one flag. So the same embryo that's property in one state is a child in another. The inconsistency isn't a quirk, it's a symptom. And like all symptoms, it tells us something deeper about the health of the body politic. The law mirrors the confusion of its makers. The United States doesn't have a federal definition of when personhood begins. It's handled state by state, and sometimes case by case. Some states grant personhood to an embryo at every stage. Others recognize personhood only for embryos carried in the womb. Some use viability. A few leave the status undefined. That patchwork isn't just inconvenient, it's philosophical chaos in statutory form. Why does this matter for estate planning? Because when you use words like embryo or pre-embryo or genetic material, or even the familiar descendant, you may have walked straight into that gray zone. In a personhood state, the same clause could trigger consequences far beyond your client's intent. In a property state, it could underperform the client's wishes. Take Alabama's ruling that frozen embryos are extrauterine children. Clinics paused IVF because mishandling could now be wrongful death. For planners, new questions arise. Can an embryo claim inheritance? Could its destruction be an act against a potential heir? Most jurisdictions still treat embryos as a form of property. You can donate, transfer, or destroy them under contract. But that line is blurring. A Virginia court refused to divide embryos as marital property, drawing a parallel to slavery. Not persons, not property, something in between. That third category doesn't fit neatly into traditional inheritance law. Florida brings this head on by statute. A child conceived posthumously with a decedent's eggs or sperm does not inherit unless specifically provided for. In plain English, unless it's written down, a posthumously conceived child is invisible in probate. Here's a clause I've heard that some Florida attorneys use. Quote, for purposes of this will or trust, the terms descendants, children, or similar terms shall include any individual conceived using my genetic material, sperm, eggs, or embryos, cryopreserved during my lifetime and implanted after my death, provided the child is born within 2 years of my death and is legally recognized under Florida law. Unquote. That's careful drafting, but is it careful enough? How might you change it if it were your client? That clause defines who counts, when, and under what law. It also instructs the personal representative to delay distribution to allow time for birth. Still, 2 years is arbitrary, and arbitrary rules, while convenient for paperwork, rarely fit contours of real life, especially when grief and legacy mix. When I had been in practice 5 or 6 years, I'd seen what I thought was every pattern. It got to the point where I was imposing my poor clients the terms of their own wills. That's a temptation. I only realized it when a document clearly diverged from what the client wanted. That client didn't fit the pattern. Then I realized a truth that made me a much better lawyer, but also made my job easier. You have to have a conversation with the client before you can help them. That sounds basic, but when a couple walks in, there's a real temptation to impose the plan on the pattern. Married couple with 2 children, right? Here they are. Here's what they need. Here you go. But once you open up a conversation and freely exchange thoughts, they'll tell you what they want. And even if most of their plan ends up being like someone else's, there will be material differences that are unique to those people, unique to them. The best clauses in an estate plan start with that conversation. And that conversation, as we'll soon learn, should include sharing your ethical beliefs. That isn't evangelizing, it's empathizing. Clients come to you not only for skill, but for wisdom. But, you say, my ethical beliefs are derived from my Christian beliefs, and not everyone is a Christian. Doesn't pluralism and science dictate that I cannot discuss Christian ethics? The answer is, yes, you can, and you should share your ethical opinions. You should share the ethical dimension of the embryo discussion, even if those ethical precepts are learned from your religion or your faith. But what about divergent state laws? Isn't the ethical dilemma solved by state law? Not really, because the state laws are not consistent. We'll come back to drafting in a minute. But first, the question everyone secretly wants answered. Can't we just split the baby and choose one rule for everyone? The irony, of course, is that the phrase split the baby comes from one of the most profound moral lessons in history. If we want consistency, we could declare all embryos children all the time, or that embryos are never children. We could declare the opposite rule and stick with that. Simply pick one and stick with it. I say we treat all embryos as property. You can buy, sell, and destroy a human embryo at will. Check. That was easy. Or we could choose the opposite rule. Since IVF is a big business, we all know what side the IVF industry would choose. Industry will push for embryos are never children. They will push for embryos as property. And they forked over huge sums of money to politicians to push for IVF always, all the time, as some kind of a human right. Just as an aside, if something costs huge sums of money, and by definition is a limited resource, and is impossible without the intervention of extremely sophisticated medical technology, can it really be said to be a human right? Anyway, getting back to IVF here, putting that question aside, the IVF all the time for everyone crowd insists that recognizing any special status for embryos would end IVF. But if all 50 states recognized embryos as persons, I think IVF could still exist. It would just be properly regulated. Here's an example of what that regulation might look like under strict, life-affirming limits. Federal licensing, fertilizing only the number of eggs intended for immediate implantation. Usually that would be 1 to 3, I think. And prohibiting creation for research, sale, or long-term storage. Now let's imagine a future where we choose the opposite. All embryos are property. It's easier to predict because we already have a regulatory scheme in place. It's called, drum roll, property law. Cue the eerie sci-fi music. All 50 states declare that embryos are property. One by one, states enact a law that all embryos must be scanned for any genetic defect that might end up costing the state more money in future Medicaid benefits. Those embryos are immediately destroyed. Embryos as property are regulated by civil contract law. That is, they're chattels. They can be sold or disposed of by the owner. Premium embryos become a commodity and are traded in blocks. Data reveal that when seeded into a community, the highest quality embryos increase the gross economic output and financial stability of those communities by a predictable amount. Intentional communities are formed that invest in premium embryo implantation. These communities sell bonds to investors. Candidates for embryo production are identified by algorithms that review their social media fingerprint, and they're paid to sell embryos to corporations. Embryos are reported on the commodities exchange. A wave of victories in the Progressive Party leads to regulation of the embryo market. The new party in power decides that these intentional communities do not fairly represent the pluralistic society, and a government agency is established to set embryo percentages. Every intentional community must contain a certain percentage of embryos from historically disadvantaged peoples. There's a court-mandated destruction of thousands of surplus embryos. Does that sound far-fetched? Even if my sci-fi future doesn't become a reality, the truth is, if we declare embryos property, human life becomes a disposable commodity. Now, think back to your reaction to my words. Which of those two choices feels more just to you? Now let me tell you an old story, and I need to warn you before I share this subversive tale. This story is from a book so inflammatory that it could not be part of the mandatory syllabus of any public school course since 1963. Talk about book banning. Once upon a time, two women both claimed to be the mother of the same baby. They brought their case before the king to decide. The king, named Solomon, called for a sword. "Divide the living child in two," he commanded, "and give half to each woman." One woman begged him to spare the child and give the baby to the other woman. Well, Solomon knew right then who the true mother was, the one who would rather lose the baby to save her life than see the child harmed. Solomon never intended to split the baby. He intended to reveal the heart. When I first heard that story as a child, I didn't know the ending, and it sent a chill down my spine. That story isn't just scripture, it's jurisprudence in parable form. A ruler who sees through legalism to discern love's truth. When I said before, quote, "Let's treat all embryos as property, buy, sell, and destroy them at will," that was a sword put to the baby. If you felt a pang of conscience at that thought, you just partook of a timeless truth. Even though we may not always honor it, reverence for life is an inherent part of who we are. Contrary to what modern bioethicists suggest, that conviction doesn't spring from a harmonious consensus of free citizens guided by virtuous bureaucrats. And that position is downright beneficent when compared to the more popular bioethical position today. Forget the older ideal of procedural justice and democratic deliberation. Today's dominant bioethical posture has shifted toward instrumental reasoning, where utility and efficiency eclipse intrinsic human worth. And when law follows that reasoning, it stops being the shield of the weak and becomes the sword of the powerful. In our world of contracts and clinics and competing claims, the wisdom still holds. Sometimes justice is found not in the clever argument or the scientific sounding rationalization, but in the recognition of an absolute value. So where does that leave us as counselors? We're lawyers, yes, but also parents, siblings, neighbors, citizens, and often we're people of faith. I would argue, in the original context and meaning of the word pluralism, those are the plurals, the multiple offices that each of us holds: parents, children, siblings, also lawyers, legislators, and people who give advice to others. Those are the overlapping and sometimes contrary places from which we each must make decisions. Counseling on embryos and inheritance isn't merely technical, it's moral work. But if you don't counsel from that conviction, you're not registering in society as a whole your true microstate. Now I'm going to venture into physics a tiny bit here. What's a microstate, right? Without enough moral microstates, the macrostate of public life cools into indifference. In physics, a system's macrostate, like temperature or pressure, is the big picture condition we can measure. That macrostate emerges from countless microstates. The individual motions of molecules, each vibrating, colliding, and transferring energy. For example, the heat you feel from a stove comes from billions of particles moving faster as they absorb energy. Now imagine a wood-burning stove on a cold morning. The stove's warmth, the macrostate, is what you sense in the room. Steady heat, comforting and predictable. But inside, countless microstates are at work. Sparks flying, logs cracking, embers glowing, air currents feeding the flames. Physics tells us the big picture emerges from those tiny motions underneath. Society works the same way. The macrostate of public morality, the law, is like the steady warmth. A burning log can't hide the fact that it's throwing off heat, but a human system can frustrate the expression of the beliefs of its constituent units. Over time, just as fire settles into the truth of its fuel and airflow, society moves toward the truth of what people really believe and live. And if the lawyers, the custodians of language and conscience, refuse to move, the flame flickers out. Now let's test your microstate. Listen carefully and watch the watcher. Don't think about your answer before answering this question. When Solomon's sword hovers over cold metal tanks full of embryos, what does your microstate say? Do you counsel your clients from that conviction, or do you hide behind the sterile language? Because this isn't just a philosophical exercise, it's about real people facing irreversible decisions. So why are people surprised when these predictable controversies arise after they've taken the plunge? Because they're not told the truth. And if they're not told the truth, there is no informed consent. There are at least two reasons why people don't consider the implications of these procedures. The first reason is simple: the language. The language used to describe what's happening never actually describes what's happening. When the consent form calls it tissue instead of child, when the contract says product of conception instead of a son or a daughter, that's not science, that's marketing. It's wordcraft designed to dull the conscience. The second reason is more subtle and more dangerous. It's philosophical. The dominant framework that drives all of this is not scientific at all. It's utilitarian and materialist, what I'd call a pre-Christian worldview. The reason I call it pre-Christian is because prior to Christ, no civilization on earth made it illegal to treat human beings as property. And I'm making the case in this episode that what we've substituted for revolutionary Christian ethics does not and will never lead to the conclusion that human beings are not property. And here's why. The modern, what I'd call false macrostate, starts with the assumption that the highest good is whatever's most efficient or least painful or most profitable. Even though they characterize their reasoning as progress or progressive, it's really regressive, that is, an ethical step backward. Modern bioethicists have taken that ancient pagan logic and dressed it in a lab coat. They've replaced moral law with what amounts to a new religion of procedure. In this faith, there are no sins, only systems. They posit an imaginary world in which fundamentally good bureaucrats and politicians make ethical rules by consensus in a society that's free from coercion. But just because they ignore coercion doesn't mean it doesn't exist. People are coerced every day, not necessarily by force of arms, but by the force of marketing or by economic despair, by the quiet tyranny of hope. Tell a couple who's been through 10 rounds of IVF and 2 mortgages that their choice is free. They're not choosing, they're praying with their credit cards. And the priests of this new faith are what we call bioethicists. Their vestments are white coats. Their sacraments are signed consent forms. Their catechism is, autonomy, and progress. And their tithes come straight from pharmaceutical profits. The modern prophets of this movement, people like Peter Singer, Julian Savulescu, and John Harris, they aren't writing your state's statutes, but their ideas are. Their language, autonomy, utility, consent, has become the liturgy of the committees and regulators who do write the laws. They tell us with the calm certainty of high priests that moral worth depends on cognitive function, that a newborn infant may be less valuable than a laboratory chimpanzee, that it's ethical to create embryos for research, destroy them for tissue, and sell what's left for progress. Their whole theology rests on two commandments, consent and utility. If someone agreed to it, and if someone else finds it useful or profitable, then it's good. That's their gospel or good news, the promise of a technological solution to every problem, including problems they manufacture in order to solve. All we need to do to reach this utopia is to harvest embryos. But consent isn't freedom when the choice is itself framed by manipulation, grief, or the illusion that technology can heal the soul. That's not ethics, that's advertising. And people, including lawyers, are coerced, not just by the promise of technological miracles, but also by the illusion that this view represents public consensus. By being told that their religiously founded convictions are backward superstition, while to treat human life as property is scientific and justifiable, and therefore ethical, where the moral and ethical viewpoint is squelched. And here's the deeper irony. They tell us we can't legislate morality. Of course we can. Every law is a moral statement. The only question is whose morality we're legislating. We haven't abolished religion in the public square. We've simply changed gods. We've swapped out thou shalt not kill for thou shalt not interfere with demand. And that's not neutrality, that's idolatry with better PR. If a procedure is profitable and someone wants it, then I guess it's ethical. That's the end game of every consensus-based morality. It's moral relativism dressed up as pluralism. And it's the philosophy that lets us redefine a human being as something else, a gamete or an embryo or a consumer of medical products, a fetus, a slave. Their moral framework, just like the ancients, doles out rights based upon the strength of the right holder to enforce them, not upon any universal principle of the inherent value of human life. Funny, isn't it? A baby can't consent, and yet the modern bioethicist depends entirely on consent to justify almost anything. Let's imagine the informed consent conversation with an embryo. Hey, how would you mind being frozen for 10 years and then gestated in a woman who won't nurse you, but instead sell you to a gay couple? What's that, you say? Are you game for that? Let's talk about two voices shaping modern bioethics. Peter Singer and John Harris. Singer argues that being human isn't enough to guarantee dignity. In his view, moral worth depends on traits like rationality and self-awareness. If an embryo or even a newborn lacks those traits, it's not a person in the moral sense. Harris takes a different angle, but lands in a similar place. He says if nature discards embryos all the time, then using them for research or enhancement isn't morally any worse. Both frameworks reject the idea of sanctity of life. But are they progressive or regressive? Let's look at something uncomfortable because sometimes that's where the truth hides. In the 1800s, George Fitzhugh wrote, quote, "The Negro is but a grown-up child and must be governed as a child. Slavery is as a form and is the very best form of socialism." End quote. He said that with a straight face. His logic was simple and monstrous. Because the enslaved were said to lack rational capacity, someone else had to make decisions for them. Ownership, he said, was kindness. Slavery was protection. A few years earlier, John C. Calhoun stood on the Senate floor and called slavery, quote, a positive good, end quote. He claimed that under bondage, African people become, quote, civilized and improved morally and intellectually, end quote. Do you hear the trick? It's the same pattern every tyrant uses. First, define a capacity, reason, intelligence, self-sufficiency. Then say, those who lack it don't deserve the same rights. Finally, claim that using or ruling them is actually for their own good or society's good. Now, fast forward 150 years, change the plantation for a lab. Peter Singer tells us, quote, the life of a newborn is of less value than the life of a pig, a dog, or a chimpanzee, end quote. John Harris argues if natural reproduction involves embryo loss, then creating and destroying embryos for research cannot be morally worse. Different century, same syllogism. Identify a capacity like self-awareness or cognitive function, viability. Deny full personhood to anyone who lacks it. Then use or destroy them in the name of progress. That's not new thinking. That's just old cruelty with better branding. The language has changed. Fetus, child, property, pre-embryo, non-viable tissue. But the move is the same. You draw a line between the powerful and the powerless, and then you tell yourself it's progress when you cross it. In the 19th century, we justified chains. In the 21st, we justify petri dishes. Either way, we're saying the quiet part out loud. Some human beings don't count. That's why lawyers, especially those who call themselves counselors, can't hide behind professional neutrality, because neutrality has a body count. If you can't see the logic that once excused owning a man now excuses destroying his offspring, then you've forgotten what law is for. Law is the language of conscience written down. And if the conscience goes silent, the law just becomes paperwork. One day, back when I lived in New Jersey, I noticed a sign just past the sign for Skunk Misery Road. Yes, that was a real road name. I saw a little beat-up Christian church with a message board. It said, quote, "What's missing?" unquote. Then, like a gang of hangman with underscores and the word only partly filled in, it was the CH, then blank, blank, and another CH. The answer was, you are, right? What's missing from the word church if we remove the U and the R? You are. So what's missing from church is you are. And that's what's missing from the bioethics debate. You are. If you believe the bioethicists are wrong and you don't counsel that way, you're missing from the debate. Because without that point of view, the conversation is left to those who see human life as a resource, not a relationship. So what does this mean for lawyers? It means we're living in a courtroom where only one side gets to speak. The prosecution has had the floor for 50 years. The technologists, the ethicists, the corporate lobbyists, they've argued their case well. But the defense, the voice of moral law, the voice of faith, the voice that remembers what a person is, has fallen silent. Imagine a trial where the accused sits waiting for his defense and his lawyer rises but only shrugs. That's what happens when lawyers of faith refuse to speak moral truth. They think they're being neutral. They think, they're being scientific. They're being objective. They're not. They're ceding the field. If you're a lawyer who understands the ethical framework of your faith and you keep it locked away because you think it's unprofessional, you're not just muting yourself. You're letting someone else write the moral code that governs your clients' lives. And here's the twist. The people who tell you to keep your religion out of law are preaching their own religion. They have faith in progress, faith in the market, faith in the self-justifying power of scientific research. None of that can be proved. It's as metaphysical as any sermon ever preached. They just don't call it worship, but it is. So why is every moral question in public life decided without hearing both sides? Why does the jury, the public, only ever hear the prosecution? Because the defense attorney, you and I, are too polite or maybe too professional to speak. The myth, the false macrostate of societal norms is that to be modern is to be secular and to be religious is to be superstitious. In their view, all science, no matter how potentially harmful, is progressive. All religious ethics are regressive. That's just false. The modern world didn't emerge by rejecting religion. It was built upon one, Christianity, which first declared that every person born or unborn, slave or free, bears the image of God. That's the moral foundation we're standing on, even when we pretend we aren't. So don't be the stammering lawyer in the Areopagus shrugging while the high priests of prophet define personhood for you. Bring your convictions into your counsel. That's what the title counselor at law means. And if you're wondering whether you're even allowed to do that, you are. The American Bar Association, of all places, gave you permission. Lawyers love rules, and here's one that matters. Although when Singer and Harris's employers hear this podcast, they'll get right to work changing Rule 2.1. But for now, at least, it stands. ABA Model 2.1 says that in rendering advice, a lawyer may refer not only to law, but to moral, economic, social, and political factors relevant to the client's situation. It also says you shouldn't be deterred from offering candid advice just because it involves unpleasant facts or unpalatable advice. You may even initiate non-legal advice when it's in the client's best interest. Translation, you're allowed to be human. You're allowed to ask the questions that matter. The Macrostate needs you. Your clients and the culture need to hear the defense. The fact is, most people need to have a conversation to come to what they believe. In other words, speaking in dialogue actually helps us understand what we actually think. It's a process that you should be part of when asked for counsel. So if a client says, we're considering IVF or freezing embryos, you can ask, do you know what happens to unused embryos? Do you understand how our state defines inheritance? Are there other ways to bring life into the world? That's not overstepping. That's being the other side of a dialogue. And yes, most of us are more comfortable talking about grits, grats, and the Secure Act. You can spreadsheet a grat. You can't spreadsheet a conscience. And most people do their thinking out loud in dialogue with someone they trust. Even when your client disagrees with you, the conversation often brings them closer to the truth that they need. And then you can get back to the mechanics of helping them make a great estate plan. Here's some nuts and bolts. Review the clinic agreements, preferably before the client signs them. They often control disposition and can conflict with your client's estate plan. These issues can arise not just after death, but potentially during a period of incapacity. If the context is preservation of the ability to conceive in the face of chemo or radiation, you need to pay close attention to the drafting of the power of attorney and the healthcare power of attorney or advance directive. Do they authorize decisions about cryopreserved material? If a client wants to disinherit DNA-only relations, be explicit. I intentionally disinherit all persons not specifically provided for in this instrument, including anyone claiming to be my descendant by genetic evidence alone. And please have the conversation about posthumous conception and distribution timing. Indefinite delays create lawsuits. Arbitrary caps without thought create injustice. Talk it through. Okay. Now it's time for a little LifeCounsel fun. And I hope you guys don't think I'm being blithe or making fun of this very serious situation. But anyways, we have to have some fun. This is my LifeCounsel Clause Challenge. Here's your clause prompt of the week. Quote, for purposes of this trust, the term descendant shall include any being conceived, assembled, or academically summoned by my genetic material, laboratory procedure, or divine or technological intervention, provided said being can prove they share my sense of humor and can properly draft a crummy notice. End quote. That's my clause entry. Now you write your own. Write your own over-the-top embryo inheritance clause. Be funny, clever, and a little unhinged. And I'll post it in the comments or send it, or you can send it to us by email. We'll share the top 5 on our socials and give you full credit unless your malpractice carrier follows us. Thanks for listening to LifeCast, Attorney Edition, part of the LifeCounsel Pro Series, where legal insight meets real life. If this episode made you think or laugh in that uncomfortable, this is too real way, share it with a colleague. Drop your mock clause in the comments. Like and subscribe so we can keep this conversation going. Until next time, work with intention, plan with wisdom, and counsel with heart. By the way, if you made it through an episode on embryos, ethics, and microstates without zoning out, congratulations. You're qualified to draft in Florida and to host Thanksgiving without crying.